Welcome everyone to the Securities Enforcement Spring Training webinar series. Hello, my name is David Pulio and I'm with Foley & Lardner's Marketing Department. On behalf of Foley, I'd like to thank you for participating in today's conference. Before we begin, we have a few housekeeping announcements. Today's program will last approximately 1 hour, followed by a short question and answer session. We encourage you to submit written questions during the program. Please type your question into the Q&A widget open on the left-hand side of your screen. We will respond to written questions at the end of the program, time permitting. The webcast console you're looking at can be completely customized. It can resize or move any of the windows that you have open, including maximizing the PowerPoint presentation on your screen. If you experience technical difficulties during the presentation, please visit the webcast help guide by clicking on the help button below the presentation window. It's designated with a question mark icon. The PowerPoint presentation will be available on our website at foley.com within the next few days, or you can get a copy of the slides in the resource list widget to your left. As a reminder, today's program is being recorded and will also be available on Foley's website within the next few days. At the conclusion of this program, Foley will apply for CLE credit. If you did not supply your CLE information upon registration, please send an email to David Pulio, me. My email address is dpulio@foley.com. To be eligible for CLE, you will need to log in to this On24 session and answer a polling question during the program. So if you are looking or watching this program through a group or communal unit, we would request that you all log in individually. As a final note, those seeking Kansas, New York, or New Jersey CLE credit are required to complete the attorney affirmation form in addition to the polling question which will appear during this program. A 4-digit code will be announced during the presentation. Please email the form again to me, David Pulio, at dpulio@foley.com immediately following the program. Now I would like to introduce our speakers for today. Joseph Edmondson is a partner in Foley's Securities Enforcement and Litigation and Securities, Commodities, and Exchange Regulation practices. Mr. Edmondson focuses primarily on defending securities litigation and enforcement proceedings brought by the U.S. Securities and Exchange Commission, state regulators, FINRA, and other self-regulatory organizations. And he has over 20 years of experience in commercial litigation and regulatory investigations. Mark Mandel is a partner in Foley's Securities Enforcement and Litigation practice. He's a former chief of the New York office of the U.S. Securities and Exchange Commission's Division of Broker-Dealer Enforcement and has over 20 years of experience as a private practitioner, focusing his practice on complex securities-related litigation and enforcement. Jonathan Friedman is a senior counsel in Foley's Securities Enforcement and Litigation practice with experience representing clients in a broad range of complex, high-stakes commercial litigation, as well as in enforcement proceedings before the SEC and various self-regulatory organizations. We're also pleased to have with us today as a guest speaker, Shay O'Brien Hicks, who is Senior Counsel for Wells Fargo Advisors. And we'll turn it over to our speakers. Thank you.
Hello, everybody. This is Mark Mandel in Foley's New York office, and I'm pleased today to present with my colleagues a very robust program. There's a lot of ground to cover this morning or this afternoon, depending upon where you sit, and we'd like to get right into it. The topics for today's presentation include the importance of the legal and compliance functions, role of compliance in the regulatory framework, as well as the role of inside counsel will be discussed today. And in connection with that discussion, we will cover issues including the attorney-client privilege, the definition of who is a supervisor, and touch on issues of supervision, as well as provide you with an update on liability of legal and compliance professionals. Finally, we'll close with a hypothetical which will help you understand and illustrate the intersection between the legal and compliance functions, and we'll conclude, of course, with a Q&A session. So without further ado, I'd like to turn it over to my colleague and partner, Joe Edmondson, so we can begin the program.
Well, thanks, Mark, and good morning, good afternoon, everybody. Greetings from Washington. It's probably fitting that the first slide here is a quote from our SEC chairperson, Mary Jo White, sitting in Washington today. This conference this webinar is about the intersection between legal and compliance. In Mark and my and Jonathan's practice, and certainly in Shay's experience, a variety of situations arise that sometimes blur the lines between who's doing what and what the roles are within a firm. So we thought that this program would try to address some of that blur. We start with the importance of compliance because what we find, you hear this year after year after year, if you go to any of the membership conferences, whether it be NSEP or SIFMA or others, almost without fail, regulators will stand up and speak about the importance of the mission of the compliance function as supported by the legal function within the brokerage industry and the larger financial services industry. This is certainly made more sharp and keen in everyone's awareness as a result of the financial crisis. But it was equally made sharp and keen by the Enron crisis before that, other crises that preceded that. Any situation where you have a problem that emerges from an industry, there is a compliance officer who is ready to have a target painted on them in order to take some of the blame, potentially, perhaps as a panacea, perhaps with some legitimacy in some cases. But we're a blame-placing society. So one of the things we want to try to do here is talk about how legal and compliance can not only fulfill their role, but can also avoid liability in so doing. So Chairman White, gave that typical speech in 2013, and we could cite other speeches where regulators have said that the legal and compliance folks have a critical mission to protect investors, ensure the integrity of the markets. In short, the regulators, I think, expect folks to have something of a gatekeeper function. That the legal and compliance are the proactive cop on the beat with a seat at the table to see what's going on and to protect and prevent and detect violations as they're occurring. The regulators cannot be everywhere, but at least in theory, the compliance officers and the legal professionals can. Specifically with respect to compliance, in a typical firm, I've devised four main roles. There are probably more, but under Rule 3010, FINRA, NASD, Rule 3012. Broker-dealer firms need to have a system for compliance, need to have controls to support that system, and for our purposes, importantly, they need to have individuals designated as the people responsible for that system. Similarly, Section 15b-4 of the 34 Act provides an incredible positive incentive for firms to develop robust compliance functions. The written policies and procedures that are reasonably designed to prevent and detect violations of the securities laws will provide a safe harbor under 15b-4 against a possible disciplinary charge of failure to supervise if brought by the SEC. So, who does this? Well, compliance. The CCO is usually responsible for the development of the written policies and procedures, perhaps assisted by legal, perhaps assisted by outside consultants, but certainly front and center in that process. once those policies and procedures are developed, the CCO will also have responsibility for creating the system whereby the firm's operations will be reviewed against those written supervisory procedures for compliance. And that can take on many functions, including the creation of compliance infrastructures where you can have dozens, if not hundreds, of individuals in a large firm that sit in the compliance department with the job of surveilling for compliance under the written supervisory procedures. In most firms, compliance also has an investigatory function, dealing with customer complaints and other red flags. And certainly when regulators come to call with inquiries or requests, compliance usually deals with that in the first instance as well. But the compliance personnel can also wear many other hats. In some firms, we see them fulfilling functions that are largely HR-related, particularly where it dovetails with registration, licensing issues, and then other things beyond that. Of course, I would be remiss if I didn't mention that CCOs for the last couple of decades have had a registration requirement where they hadn't had that before. First at the New York Stock Exchange and then more generally. So it's a well-regulated and important role that you all that are on the line that are compliance officers fulfill. So with that in mind, let's talk about what the role of legal is and how it supports the compliance function. And with that, let me introduce Shay Hicks.
Thank you. As we all know, the legal department often works hand in hand with compliance, and in a lot of situations there's some overlap as to what's occurring in both those departments. Normally speaking, inside the legal department there'll be an array of different responsibilities there, and depending on the size of your firm, you may be involved in one of these, or in often cases in smaller firms, you might be doing all of it. But generally speaking, the lawyers, they help interpret the rules and the laws. They respond to regulatory inquiries. They defend customer complaints and litigation and provide insight on which cases to settle or try. They help enforce the rules and policies and regulations internally within the firm. Often they're involved in conducting internal investigations or helping support those. They provide advice and counsel on employment issues. They can be involved in helping train FAs and branch managers as to the firm expectation and industry rules. They can be involved in advising the compliance function as needed. They're often involved in advising management, and often are looked at as the voice of reason or as a soundbite for sound judgment and making business decisions for management. And again, in smaller firms, you can be involved in many, if not all, of these issues on a daily basis. So with that, we'll turn it over and talk about the General Counsel and Chief Compliance Officer and whether it makes sense to have a person serve in both of those roles.
Okay. Well, obviously, there may be certain situations where combining the two functions is absolutely essential, and that would particularly be in a case where you have a small firm and the resources may be somewhat limited, so it makes economic sense to put these two positions together and combine them. And again, in my view, this occurs more frequently in a smaller firm setting than it would in the more larger firm. In that instance, there may be a cost savings involved, and the compliance decision may, I say may, arguably become privileged, but you need to be aware of certain pitfalls where the staff may come in and say everything is available to us because the individual is functioning as a compliance person as opposed to a legal counsel. and in that instance, the privilege may be in jeopardy. So there are pros, there are cons. Obviously, on the negative side, you will be exposing yourself to advice of counsel, scrutiny. You may get into a contest with the staff as to whether or not certain issues are protected or not. And perhaps even more importantly, or equally important, is the fact that you're removing the buffer or the detachment that you have as counsel dealing with the staff as opposed to having the compliance folks dealing directly with regulators, employees, adversaries, and the like. It's never a good situation to have folks in compliance, unless you're dealing with a very mundane issue, to be talking with the staff, or the enforcement staff in particular, on matters that may be of concern to enforcement, because those folks may ultimately be the people who will provide testimony and bring forth evidence and explanations and the like. So it's always very helpful to have counsel step in, and that's why separating these functions probably the better course to take if it's economically feasible. So now we will look at supervision.
Thanks, Mark. So the role of compliance officers has changed. Traditionally, a supervisor was someone with the ability to hire and fire, affect the conduct of employees, in short, the power to direct employees. Traditionally, compliance, in contrast, sat apart. It was compliance departments were a tool used by supervisors of business line management. They would receive review tasks that were delegated to them by the business line. That role is now more integrated. There's more active participation and engagement with firm personnel. There's more of a team approach. And that has created the risk that compliance and supervisors now have a much more blurry line between them than used to exist. Because, as we're going to talk about, becoming a supervisor is associated with liability, firms should be making a conscious decision about whether they want their compliance personnel to serve as supervisors. For smaller firms, it's inevitable that a compliance officer may have to wear two hats and be on both sides of that. But bigger firms in particular should be aware of the ways in which a compliance officer that is who is intended to be just the compliance officer can become a supervisor under the law to ensure that that does not happen accidentally. So to that end, it's worth talking a bit about the state of the law in this area. One of the seminal cases in this area that many of you are probably familiar with is the Gutfriend case from 1992. This was best known in the press for ultimately causing Salomon Brothers CEO John Gutfriend to resign. But for our purposes, it is important as the first case to directly address failure to supervise liability for legal or compliance officers. The background here is that the Treasury Department limited the maximum bid from one bidder in an auction for U.S. Treasury securities to a particular percentage, 35% of the auction amount. Here, a Salomon Brothers trader got around those limits by placing bids in his customers' names without the knowledge of those customers, then caused those securities to be sold to Salomon Brothers. The broker ended up describing his conduct to his supervisor, who reported it to the firm's CEO, the firm's president, and the chief legal officer, Donald Feuerstein. Chief Legal Officer Feuerstein identified this conduct out loud as a criminal violation in a meeting with these other executives and advised that it be reported to the government, but no one did. Meanwhile, the broker continued to engage in this apparently improper trading. After a while, the press caught wind of these trades and the SEC investigated. The result here was that the SEC sanctioned the CEO, the president, and the broker's direct supervisor for failure to supervise. The SEC did not sue Chief Legal Officer Feuerstein because he was not a direct supervisor, but there was some dicta in here, some discussion in which the SEC put legal and compliance officers on notice that in the future they could be deemed supervisors and face liability for failure to supervise. And in particular, the case notes that a legal or compliance officer can be deemed a supervisor if, under the facts and circumstances of a particular case, that person has a requisite degree of responsibility, ability, or authority to affect the conduct of the employee whose behavior is at issue. And that language is a bit nebulous, and it created a concern that a legal or compliance officer who actively engaged in responding to observed misconduct could be exposed to liability, and interestingly, could be exposed to liability that a more passive officer would avoid. So coming out of that case, there were questions about what the exposure was and what the incentives were for compliance officers. Some of those questions were addressed in the 2010 Ted Urban case. Story here was that traders at the broker-dealer Ferris Baker Watts bought shares of a company through customer accounts in order to acquire a significant cumulative position. The GC, Ted Urban, reported a concern about market manipulation going on to senior management. He temporarily stopped the trading, and he recommended that the trader be terminated. Nevertheless, the trading continued. In response to the General Counsel's recommendation that the trader be terminated, the head of retail trading suggested, instead of terminating him, not terminating him, and instead putting him on what he called special supervision. It's important to note that the head of retail here was a very influential executive within the firm. He was the former CEO and had an antagonistic relationship with the compliance department. In the face of that, GC Urban withdrew his recommendation of termination, and once the regulators got involved, the SEC ended up suing the General Counsel, and the case was tried before the SEC's chief administrative law judge, who ruled that, affirming the concerns that had been out there, ruled that the General Counsel was the trader's supervisor. The judge's reasoning was that as General Counsel, Urban's opinions on legal and compliance issues were viewed as authoritative, and his recommendations were generally followed by people in the firm's business units. And part of the concern is that seems to be not a very high bar for being deemed a supervisor. Fortunately for the General Counsel here, Ted Urban, the judge also held that although he was a supervisor, he had acted reasonably as a supervisor. He followed up when confronted with a red flag. He reasonably expected the head of retail sales to follow through on his statement that he would supervise the trader, and he had no good alternate options, the court found, because challenging the head of retail trading would have been futile. So the bottom line from this case is that the holding worked out fine for the general counsel himself, but it substantiated a concern that legal and compliance officers could be treated as supervisors and added to the uncertainty about when they would be. Quick note about the Batista case, since it's a very recent case, it came out April 20th, 2015. This is not a failure to supervise case. The SEC in this case alleged that BlackRock had failed to disclose a conflict of interest to its boards and clients. Specifically, a BlackRock fund had invested in a company that formed a joint venture with a family-owned company founded by the fund manager. There was a $12 million fine for BlackRock, and the compliance issue came in because BlackRock did not have, supposedly, and the chief compliance officer, Bartholomew Batista, did not recommend policies and procedures regarding the outside activities of employees that the SEC thought might have addressed this issue. So this case is in here as a reminder that failure to supervise is not the only trigger for SEC enforcement. So back to the failure to supervise issue and the line between compliance and supervisors. In the wake of the Urban case, the SEC recognized that there was some uncertainty out there about where that line was, and issued on September 30th, 2013, a document called Frequently Asked Questions that, in essence, tried to provide some clarity and some reassurance about its view on this topic. And it noted that the staff does not generally single out compliance or legal personnel, at least as a general matter, so that may be small comfort, but rather is trying to encourage people with those positions to take strong and vigorous action when misconduct becomes visible. The FAQ also clarified that compliance and legal personnel do not become supervisors just because they have provided advice or counsel concerning compliance or legal issues to business folks, or because they assist in addressing an issue that comes up, but rather they become supervisors when they have the requisite degree of responsibility, ability, or authority to affect the conduct of business line personnel. And as for what that phrase means, the SEC clarified in this FAQ that supervisory responsibility, as defined by or described by that phrase, is only determined once a legal or compliance officer has been given responsibility over a business activity, so that's responsibility in practice or in writing in the policies and procedures, identified as a responsible person with respect to something relating to the business line, or relatedly, given the power to hire, reward, or punish employees for their conduct, or, and this is kind of a catch-all, in a position, generally speaking, to have prevented a violation from occurring or happening again. So the bottom line moral from this is that if a compliance officer is in such a position, the SEC wants you to understand that the SEC wants you to take an active role and do what you can to prevent or stop such violations. They're trying to encourage proactivity. And that's the bottom line from the SEC's FAQ. And for the even more recent wisdom on this, I turn it over to Mark.
Actually, I think it's Joe, but that's okay. So thanks, Jonathan. Before we get to Seresny, which is on your slide, just to keep this in the correct order. So after those facts were issued, SEC Commissioner Dan Gallagher gave a speech to FINRA's internal enforcement staff in November of 2013. And the interesting thing is that Dan Gallagher is a former general counsel of a brokerage firm himself, and he was rather strident that in his comments that he felt that it was important, and these are my words, that the specter of liability for compliance officers and general counsel not chill the important role that they have in preventing and detecting conduct. So if you put too much of a target on someone's back, they might refrain from asking questions when you would want them to act. They might refrain from getting involved where you would want them to get involved. And what Commissioner Gallagher said was, we want to encourage these officers to, quote, run toward problems, not away from them, in that speech. And so then you fast forward to Andrew Seresny's comments in May of 2014, where he said, I would only seek to bring cases if a compliance officer participated in misconduct or failed to implement policies, and urged officers to help fix problems if they see them. I do not want you to be concerned that by engaging you will somehow be exposed to liability. Now, that's taken a bit out of context. I have no doubt, and I'm sure my colleagues will agree with me, that in the case where a compliance officer or a general counsel has supervisory responsibility and ignores a red flag, that they will not escape liability by virtue of Director Seresny's comments. But it is of some comfort here that at least the regulators realize that there is a bit of a dichotomy, that there is an important role that you folks, most of you on this call, play, the industry, and that the regulators are shooting themselves in the foot, frankly, if they decide to be too harsh in their criticism of legal and compliance responses to events out there. So, Mark, what other takeaways can we bring from all this?
Well, just to follow up on what you had just said, I think everybody on the call today, if they don't know, they should know, but I'm sure they do, that with this present commission and enforcement program, we're all on notice, whether in outside counsel or in-house or compliance professionals, that this is a commission with the benefit of hindsight will take a very hard look at everybody's conduct and put it under a microscope and put people in some uncomfortable positions because they're very, very aggressive. And I think some of the takeaways that we have from the prior commentary would be, obviously, the compliance role should be clearly defined. While there may be less concern about getting involved than there once was, I think we all need to be mindful of the fact that this is a very aggressive enforcement program and intends to use the benefit of hindsight to apply their view of the facts as opposed to how things may have actually played out. And that's where the rubber's going to meet the road. Interestingly, FINRA had reported, at least one of their senior enforcement folks had reported that in 2014 it had brought no cases against compliance officers. Notwithstanding those comments, I hasten to add that if you do a little bit of research, you will see that there were a number of cases that FINRA has brought involving compliance and chief compliance officers at that. These are all cases that are worth looking at. We'd be happy to furnish anybody who was interested in with copies of any relevant cases or commentary. And I think, again, the trends in enforcement, unfortunately, at this point, the pendulum has still swung to far to one side, and that is a very aggressive, hardline approach to how we, as compliance professionals, react to certain fact patterns. And again, unfortunately, they're not looking at it in a real-time basis, but they have, unfortunately, the benefit of hindsight. So everybody needs to be on their toes, and when you get involved, you have to run things to ground and have a 360-degree mindset, because things are going to be coming at you from all different directions. Well, that brings us to our next segment of the program, which involves our hypothetical.
Okay. We're going to discuss quickly some facts related to a hypothetical to kind of discuss from a practical standpoint the issues surrounding the interplay between legal and compliance functions at a broker-dealer. So with that said, to get started, our hypothetical involves a local CPA by the name of Ty Cobb, who gained trading authorization over 19 firm customers, and the firm today will be White Sox Financial. And he's gotten trading authorization through powers of attorneys that have been signed by the customers. And the firm learned of this situation when a trading review report showed that these 19 accounts were buying and selling the same security at simultaneously or in quick succession. So it showed up on a close proximity report. And this caught the eye of the compliance department, who noticed that all 19 accounts were from the same branch and involved the same reps, Jackson and Weaver. So in connection with that, the two reps in the branch, Jackson and Weaver, were asked about the close proximity of the trades, and they maintained that they did not recommend any of the trades to the customers, that the only commonality between them was that they have the same tax preparer, Cobb, who is both a personal friend of Jackson and Weaver, basically approving or giving instructions for trades in the account. And a further review reveals that the orders were placed online. So, Mark, you want to take that hypothetical and kind of start a panel discussion?
Is Mark on mute?
Yeah, sure. That was some brilliance that you all had just missed. But at this point, what we have is a unique fact pattern that is developing, and because of the trades that were placed online, I'm wondering what, if anything, folks are going to do in the compliance department to run this issue to ground, particularly without more detail, now that Jackson and Weaver have assured them that they were not involved in these trades. How much more digging, Shay, can we do in order to try to unearth more information that may cause us to take action one way or the other?
Well, here the compliance personnel that have discovered that could be asking themselves, the question is whether the CPA is acting in the role of an investment advisor, and what exactly does that mean for the firm? Is this permissible conduct? Does it violate any firm rules? And are there any registration requirements at either the SEC or state level?
But again, the firm has a blind spot because they don't have access to the CPA. So that does present a bit of an obstacle for the folks in either legal or compliance, whoever are dealing with this issue. Would you not agree?
Correct. It definitely does. And it's unclear, I guess, at this stage of the hypothetical as to whether the clients selected this agent on their own or whether there was any participation by the brokers in either recommending this person or, introducing the CPA to the clients.
Okay. Well, as we flip to the next slide, we see there's a new development.
So at this point in the hypothetical, one of the customers comes out and complains that she is being charged a commission by the firm for each of her trades, while Cobb is also charging her an asset management fee of 2% of her account value per year. And in her letter, she specifically refers to Cobb as her wealth manager.
Okay, so there it is. Now we have a customer complaint letter. Generally, in this instance, most of the large firms have a customer complaint resolution department, typically sits in the legal group, and for reasons of privilege, it's always advisable to have whoever it is who's responding to the complaint letter cloaked with the legal department, so privilege and work product protections are in place. At this point, Shay, I imagine the individual or individuals involved in the complaint response unit will want to start gathering additional facts, perhaps conduct more formal interviews. There may be legal analysis. Obviously, there's somebody who needs to respond to this individual's complaint, and there even may be some reporting requirements and obligations that get triggered. I take it that it's best if somebody in the legal group conducts whatever interviews are necessary and deemed appropriate in order to protect them as privileged and or work product in case litigation ensues or in case perhaps a regulator surfaces once the issue of the customer complaint becomes known to either FINRA or perhaps even the SEC. In my experience, I've seen more often than not customers who send in a complaint to the firm will CC it to, among others, SEC or a local FINRA office or perhaps even a state attorney general. So Shay, what comments do you have, if any, about that?
Well, it is always recommendable or recommended to have an attorney involved in the complaint process, but that unfortunately is not always the case. A lot of times these complaint resolution groups, are permitted to act on their own, whether it be up to a certain dollar amount or depending on the issues before legal personnel actually get involved. In this particular instance, it's unclear as to what the dollar amount of the complaint is. That may have bearing on who actually is involved, but whoever it is will most likely reach out to the broker and either request a verbal interview or a written statement from the broker kind of addressing the issues outlaid in the complaint. They'll also probably start pulling together the documents, the statements, confirms, new account agreements, and the like to begin preparing the response. And, as you pointed out, a lot of what seems to be in the PIABA playbook nowadays is not only sending the complaint to the firm, but also including a regulatory body in that may start asking questions that could be a trigger to get the legal department engaged.
So things are starting to develop. And as we skip to the next slide, we see there's additional facts that are learned.
So in this scenario, it comes to light that Jackson and Weaver were introducing their customers to Cobb. They knew about his management fee, and in fact, they've been receiving a 20% share of the fee without disclosing any of this to the firm.
Well, this is an interesting development because now this is information that's at odds with what Jackson and Weaver told the staff or the compliance staff when they were initially interviewed about this. I mean, they either omitted these important facts or they perhaps lied or misrepresented those facts. When you have a situation where an employee is misrepresenting facts as part of an internal interview, Shay, is that grounds for termination on the spot?
Well, it's an immediate red flag, and it could very well be grounds for termination. I would think that in this particular case, there would be a major concern that would require legal personnel to get involved. It might be a good idea at this point to place the employees at a minimum on some type of administrative leave until an investigation can be thoroughly carried out, and whatever employee discipline at that point decided upon, and how to deal with this particular customer, and then also a deep look into whether other customers are involved and what's the impact there as well.
Right. So under this scenario, it looks like we've got customers that were harmed by being sort of double dipped on their fees, notwithstanding maybe the underlying issue of whether Cobb is qualified to even be an advisor or some kind of portfolio manager, as it may be in this situation. But at the very least, you've got customers that are charged a commission because we know that from the customer complaint, and now we know that there's a management fee, and then there's the split of the management fee, which is an outside business activity for Weaver and Jackson that apparently was undisclosed. So so we've got a lot of things swirling around here. It probably makes sense to at least have somebody from the HR department, if not outside employment counsel, involved in a situation like this that's particularly messy from an employee standpoint.
For sure, and depending on the size of the firm, there very well may be employment counsel at the firm internally, which deals with these types of issues. You've obviously got some regulatory issues that could arise as well, and then the issue, depending on the size and scope of all this, as to whether there's any type of self-reporting requirements.
Okay. Now, when you have a situation like this, one of the things that I'm always concerned of as a litigator is do I have my witnesses available to me? This sounds like this might have to be something that will be defended either in a regulatory setting or perhaps in a civil setting. You mentioned PIABA. This kind of a multiple customer, single broker kind of a situation seems to have PIABA written all over it. And so if we put these guys on administrative leave, Shay, are we going to have access to them in terms of being able to interview them? Or are they going to still be required to deal with us? And if we choose to terminate them, do you think we've lost them forever as potential cooperative witnesses?
Well, that brings up several issues. If they're placed on internal leave or admin leave, one of the requirements of that is that they participate and make themselves available for interviewing, and they agree to cooperate in the investigation. From a practical standpoint, they may or may not comply with that. They may or may not find it worthy of them resigning from the firm at that point, and you do put yourself up against a hard spot when you're unable to interview them. On the flip side, if they truly have done something that's against the regulatory scheme or the internal policies and have actually caused harm to clients, having them on for additional time is probably not advisable to the firm either. I mean, in a perfect world, we would have their cooperation and be able to defend, but from a practical standpoint, given the facts that are outlined here, it's unlikely that that's going to be the case.
Right. So it sounds like we need to take a customer first standpoint, and if that means that if we're going to have to do some kind of restitution to customers, which may then lead us to some kind of a Rule 4350 reporting requirement with FINRA. Of course, if we terminate, we're going to be U5ing these individuals. All of that is going to bring further scrutiny to the firm, but under the circumstances, you got to do what's right by the customer first and deal with the collateral damage to the firm potentially after that, right?
Just by virtue of the complaint itself, there will have to be a disclosure made on the broker's. It would be as U4 if he continued with the firm, and U5 if no longer with the firm. But either way, that's going to it's going to raise questions from the regulatory standpoint, and you're undoubtedly going to get a regulatory request as soon as that disclosure is made. And one of the primary things that the regulator is going to be looking for is how are the customers dealt with, and did you do right by them? I think that will be concern number one. And then concern number two from FINRA or the regulatory standpoint would be, does this individual, has their conduct risen to such a level that they need to be barred from the industry?
Right. Okay, well, there's a lot more we could do on this particular thread, but we want to get to the almost inevitable regulatory inquiry. So, add the additional fact, perhaps?
Yeah, the firm now receives a letter from FINRA addressed to the CCO asking the firm to provide the details regarding all customers solicited by COB and documents and information regarding the supervision of Jackson and Weaver.
So we are now past the opportunity for self-reporting, so that question is off the table, and faced with a live regulatory inquiry. And Shay, these inquiries come in various flavors. They can come from the examination staff or the enforcement department. They can raise serious issues or less serious issues. They can have the indicia of a disciplinary case that may result. They can raise novel interpretation of rules and law. They can request on-the-record interviews, OTRs, or not. So my question for you is, once there is a regulatory inquiry, do you always get legal involved at that point? Or if it's sufficiently routine, could compliance handle the regulatory inquiry on its own, at least as an initial matter?
Well, I guess it depends on the firm, but, ideally, in a perfect world, your legal department would definitely be engaged at this point. There's no question that there are significant legal issues and consequences for the firm depending on how it's handled, and issues that should be addressed by your legal function.
And what are the benefits you get by having legal address the inquiry rather than the compliance department handle it?
Well, for one, if there is an internal investigation involved, you have the benefit of possibly cloaking it with the privilege You've often in the regulatory kind of area, you've got in-house people that have a regular relationship with the particular offices of the regulator that you may be dealing with that are invaluable. You're signaling to the regulator that as a firm you're taking the matter seriously and you're trying to do what's right and partner with the regulator in dealing with the registered representative and making sure that he's dealt with from an industry perspective in the appropriate manner.
Is there also a benefit to having legal kind of as an independent entity come between compliance, which may have had some involvement in monitoring the underlying misconduct, rather than having compliance deal directly with FINRA?
For sure. The supervision kind of layers will most likely be looked at by the regulator, and by having somebody who's not involved in that type area, it could prove invaluable as well.
Great, and I suppose we would also, the other related benefit is to the extent any disagreements arise in the course of the inquiry, if the staff's view of the lawyers handling it becomes somewhat dimmer in the context of hashing out those issues, that is probably better than leaving the staff with a colored view of the compliance folks.
For sure.
Let's see. And are there? At what point do you think about bringing in outside counsel to help with a regulatory inquiry?
Well, if it's clear that it's going to go down the enforcement road, and depending on the amount at issue and or the complexity of the issue, or the size of the documents that might be involved, it's often advisable to go ahead and get outside counsel involved as well.
In terms of reporting up to senior management about what's happening with this inquiry, are there advantages to having it handled by either compliance or legal?
It's definitely more advisable to have it handled by legal, because you can potentially, or what should happen in a perfect world is those communications should be privileged, and the regulators at this point seem to be willing to not challenge the privilege, and that they haven't been aggressive in doing that. So from that standpoint, having your legal function involved is probably best.
Great. Okay. So it sounds like we lawyers are on the panel are concluding that the lawyers are best equipped to handle it. So, Shay, anything else you want to add on the hypothetical before we move on?
No.
Okay. So with that, I will kick it over to Mark for some more lessons.
Right, so here I think the takeaways are be proactive. During the course of that hypothetical, there are a number of steps along the way where certain actions that are taken could have a definite impact on what ultimately follows up, which is regulatory involvement. There may be an opportunity to package this up, gather all the facts as quickly as possible, make restitution if restitution is necessary before you bring it to your local regulator in order to try to claim extraordinary credit and avoid having to make the call to your friendly local outside counsel when he or she has to step in order to assist what may be the aftermath. So hindsight, of course, in this instance is 20/20 because you have the benefit of the look back. But as you're going through these processes and these steps, and given the fact that we normally have 98 balls up in the air at once, it's easy for the regulator to conclude that more could have been done, should have been done. But let's try to look at it as a glass half full. These types of instances provide opportunities to not only evaluate current written supervisory procedures, but consider enhancements, and doing so as soon as possible, looking at the quality of the supervisory response, as well as coaching, counseling, or disciplining if necessary, to promote improvement to the overall program. Consider what remedies are appropriate for the affected parties, namely the clients, and whether restitution is necessary. And then be proactive by maximizing the firm's standing with the regulators, and of course improve your litigation posture when and if a private client litigation ensues.
All right, so I think that brings us to the question and answer portion of the program. We're right just past the top of the hour. We did have a couple of questions. One person asked whether there were, we paraphrase it to say, is there any rule of thumb when you're dealing with OC at the SEC or member regulation at FINRA as opposed to the enforcement staffs of either of those in terms of whether or not you bring counsel either inside or outside into the mix? I know in some instances people would say, well, if it's just going to be OC or it's just going to be member reg, we don't need to bring in the lawyers. Jonathan, that's kind of your section. What do you think about that?
Yeah, I think that's right, Joe.
So if you have one of the things that I try to use, it may not be necessarily member reg, OC versus enforcement, but if anybody's going to be under oath and on the record, I think that begs for the extra skill set that a lawyer brings to the prepping of the witness and the creation of some factual preparation that might help guide the testimony. Another question that we had was whether D&O coverage covers litigation costs for a CCO, a claim against a CCO, when the CCO may not necessarily be an actual officer of the company. That raises a number of issues. I'll just raise one, the coverage issue. I'm not a coverage counsel primarily, but this issue does come up, and 2 points. One is that surprisingly, perhaps, there have been some courts that have found that a subpoena to a firm or to somebody within the firm, an officer or director, is considered within the definition of claim under some D&O policies. The other point that I'll make is that increasingly separate insurance is being offered as a rider to D&O coverage for specifically for regulatory claims. Historically, it's hard to get regulatory claims covered, regulatory expenses, regulatory investigations covered, but that product is being offered. Mark, have you had any experience on that?
Not specifically, at least from the broker-dealer perspective. And I don't know if Shay has any that he could add.
I have not.
Well, I think if the CCO is not an officer, I mean a formal named officer, vice president, so forth of the company, that's probably I don't want to say it's a mistake, but to me it says that the person that you've named as your CCO doesn't have enough authority in the company to really be an effective CCO.
I think the way I generally see this issue arise is that these individuals have indemnification rights traditionally, and the firms will typically provide separate counsel for those types of matters where there may be a conflict, or have that individual represented by the firm's counsel if there are no perceived conflicts. But the D&O issue is not one that I've seen in this space. Right, I think we need to do the CLE poll at this moment.
Yeah, at this time, I'm going to read the CLE code out loud for this program. As a reminder, if you are seeking CLE credit for this session and you are seeking Kansas, New York, or New Jersey CLE, you will need to complete the polling question, and you will also need to complete the attorney affirmation form. There's a PDF of that form in the resources widget, which should be on the left side of your screen. That form will need to be emailed to me. Again, my name is David Pulio. My email address is dpulio@foley.com, and I'll be sending that out into the Q&A widget as well in a moment here. The code for today is 7Q8Y. So that is 7Q as in Quebec, 8Y as in Yankee. Please type that into the box now and click Submit. And we'll stick on this slide for another 30 seconds or so and let everyone finish. Again, the code is 7Q as in Quebec, 8Y as in Yankee. All right, thank you. At this time, the poll is now closed, and I will return the program to our speakers for any final concluding questions. If there is any other questions that need to be asked or fielded, please post them in the Q&A widget, and I will be again noting my email address in that widget shortly here.
All right, with that, I see no further Q&A. If anybody has any questions, I do notice some Q&A regarding the CLE code, so David will handle those offline. But without any substantive questions, I want to thank Shay Hicks and my partner Mark Mandel and my colleague Jonathan Friedman for the wonderful program and for everyone's participation on the line today. Stay tuned for future programs. If you have any suggestions for topics that you'd like to see covered, please feel free to reach out to any one of us. We're more than happy to fill any needs for CLE or other enrichment that any of you have in the months to come. So thanks again very much.